3, 2, 1, ready, start. In such circumstances, which are limited and explained hereinafter, can in a limited case upon an order being passed by the maintenance tribunal oblique appellate tribunal declaring the instrument as void can, as a necessary corollary and as consequential impact of the order, the possession may be put back with the senior citizen and only to that limited extent, the tribunal may pass an order of restitution that can be implemented and, if need be, through the district magistrate by taking aid of the police authorities. In our country, we adhere to the rules of law. Possession of a party is viewed with sanctity, and any act of a person to disturb the possession is viewed seriously. Significantly, there is a distinction which has to be kept in mind considering an act where a person may be in the actual process of trespassing as opposed to a situation where a person may have trespassed and settled his possession. In this regard, the observations of the Apex Court in Ramratan versus State of UP will be relevant, which is reproduced as under. Para. We, however, think that this is not what this code meant in defining the nature of the settled possession. It is indeed difficult to lay down any hard and fast rule as to when the possession of a trespasser can mature into a settled possession. But what this court really meant was that the possession of a trespasser must be effective, undisturbed, and to the knowledge of the owner or without any attempt at concealment. For instance, a stray or a casual act of possession would not amount to settled possession. There is no special charm or magic in the word settled possession, nor it is a ritualistic formula which can be confined in a straitjacket, but it has been used to mean such clear and effective possession of a person, even if he is a trespasser, who gets the right under the criminal law to defend his property against attack even by the true owner. Thus, in our opinion, the nature of possession in such cases which may entitle a trespasser to exercise the right of private defense of property and person should contain the following attributes: that one of the usual tests to determine the quality of settled possession, in the case of cultivable land, would be whether or not the trespasser, after having taken possession, had grown any crop. If the crop had been grown by the trespasser, then even the true owner has no right to destroy the crop grown by the trespasser and take forcible possession, in which case the trespasser will have a right of private defense and the true owner will have no right of private defense. Stop. It will be relevant to observe that injunction is one of the most prolific preventive reliefs which are sought and granted by the courts, however, the tribunal or the district magistrate in terms of rules of 2014 have not been invested with any such power. Thus, where the tribunal or the district magistrate does not have the power to grant the injunction to prevent a breach of the legal obligation and then to suggest that the same tribunal or the district magistrate, in absence of any clear conferment of power, has been granted the power to evict a person becomes incongruous. There might be a situation where some substantive proceedings are pending in a court of law which involves a senior citizen oblique a parent, where contentious questions may be under consideration, including a relief of possession oblique eviction. Then, whether simultaneously it can be said that the senior citizen oblique parent may approach the tribunal or the district magistrate and may obtain an order of eviction oblique possession through summary proceedings while the other party remains engaged before the regular courts also does not seem to be in consonance with the scheme of the Act and the rules. Thus, for all the aforesaid reasons, this court opines that powers exercised in terms of Section 21 of the Act of 2007 or in terms of Rule 21 and 22 of the Rules of 2014 cannot include passing of an order of eviction except as explained above, where Section 23 of the Act of 2007 applies. The Maintenance Tribunal constituted under Section 7 of the Act of 2007 in exercise of its power under Sections 7, 8 and 9 are not empowered to pass an order of eviction while deciding an application before it in terms of Section 5 of the Act of 2007. The Appellate Tribunal in terms of Section 15 and 16 of the Act of 2007 is also not conferred with the power to order an eviction except wherein an appeal the Appellate Tribunal allows the prayer of the senior citizen oblique parent arising out of the plea of Section 23 of the Act of 2007.